Good morning, Senator Smucker, Senator Smith, members of the committee. My name is Steve Dunham. I'm the General Counsel of Penn State. I thought I'd give you a very brief overview of my perspective on state-related universities, Penn State, and higher education in the Commonwealth. We are clearly public universities, and want no doubt about that. We are public universities and proud of it. But we have private attributes and characteristics in both the way we get funding and the way we perform our services.
Do you know how many other Big Ten institutions are covered by their respective states' right-to-know laws in a complete way?
So my general understanding is that most, if not all, are in some way covered. I have a general understanding that most of them, University of Minnesota, where I've spent some time, was covered with by the more detailed right-to-know requirements that are similar here. And I would just say that I think it's there are apples and oranges here, and just because another institution it works there, or in another state it works there, doesn't mean it's the right thing to do as a public policy matter. We really, Penn State and the state-relateds are different from the way higher education is structured in those other states. Not just levels of funding. They are different in governance issues. They are different in mission. They are different in the way the structures are set up. They are different in the policies for enhancing revenues. So I think you are correct, the implication that the other Big Ten publics are more likely covered than we are here. But I think it's important to acknowledge that they are also different than we are here in real and important ways.
Take the University of Minnesota, just for example, where and I'm sure the University of Minnesota engages in similar research, has intellectual property that it possesses, tech transfers, all of those commercialization issues. On that specific issue, and I think that is a legitimate concern that I think everyone has with respect to the state-relateds being covered. We certainly don't want to prevent your respective institutions from being the economic engines in your communities that you all are, I believe. But on that specific example, not getting into whether Minnesota was under state control or anything in that context, but on the tech transfers, the commercialization, the vendor agreements, were those items covered under Minnesota's right-to-know law, if you recall?
You know, the answer is I don't. That was in a nascent stage of tech transfer in universities. The federal law that helped prompt a lot of the patent exchange was brand new, and I simply don't recall. I do think there's a broader issue I don't want to lose sight of. By using examples, I don't want to suggest that those examples could be dealt with by, you know, an exception or two. I think that's I think we have a broader concern. You know, the broader concern is the financial difference. The broader concern is the legal nature of our institutions. But it's also the broader need of these institutions to be able to compete more broadly in the marketplace and respond to differences. So I understand the temptation, if you will, to look at specific examples, and we could carve out an exception for that. And I don't think that solves our concern, because there's a broader need for us to respect the separate identities and the separate missions that we serve.
Yeah, and I think we all want to encourage the economic development and research and the tremendous economic development and research that occurs at all your institutions. But I guess my question in the context of whether this has been a practical concern at other state institutions that conduct significant research and development and commercialization of the technology.
Well, I can say it's been a practical concern. Just reading the academic press recently, that it's been a major issue discussed at a number of institutions. But I know I'm repeating myself, but I think picking off particular exceptions underestimates the challenges of a broader application of the law to the state-relateds in ways that would be really harmful.
And this will be one of my questions, whether or not you think the right-to-know law should apply to the Board of Trustees of the universities, whether we limit it to that scope, the actions of the boards who become stewards of those state dollars that we send to them, become agents of those state dollars, whether or not a right to know should include in a very direct and specific way the actions of the Board of Trustees of the state-related universities.
And you referred to attorney-client privilege, and I just can't let this opportunity go by as a lawyer for a client for whom that's a important privilege. There is, of course, an exception in the right to know law to privilege, and there's exception in law in general. But a major misperception, in my personal opinion, is that the attorney-client privilege somehow hides the truth. I believe, with all respect, it is absolutely 100% the opposite. The reason an attorney-client privilege exists for Penn State or the Commonwealth or an agency or any other institution is to further communications between clients and lawyers, which the law has decided in Pennsylvania and every other state in the United States and in the federal system that furthers justice. It furthers the search for truth. It allows people to be open and honest with their lawyers. It allows an investigation to take place that can protect whistleblowers. It allows gathering information from people who are scared if they say something that some powerful member of the community will come down on it for expressing a view. It permits that conversation to go forward in confidence with subject to privilege. And I would submit to you that the attorney-client privilege is not an attempt by Penn State or any other entity to close off debate or to close off the search for the truth. The Board of Trustees of any university, any corporation, Board of Directors, Board of Trustees, is just part of the entity. It's the highest body within that institution charged with running the entity. It's not a separate person. It's not a separate third party. It is the entity that has responsibility. And it was cited, I believe, in the statement that each of our boards has been delegated, by charter, the power to run the institution. That means they are part of the institution. So now you move to attorney-client privilege, and you say, okay, who owns the privilege? One of my areas that I've done most writing about and speaking about are the ethics of organizations, and particularly the legal ethics of organizations. And the ethics of organizations start with the board. The board owns the privilege. That's who you communicate to. So yes, the board is covered. It's covered by as part of the university, and it's covered as an appropriate part of privilege if lawyers are communicating to the board of the entity, whether it's Pitt or Temple or Lincoln or Penn State or, frankly, PASHE or any agency. Lawyers are communicating with those people who are charged with fiduciary duties, and that's the board. So yes, they are covered, and we do believe the privilege applies, and we believe for that privilege not to apply, not just the whistleblower, but also for communications, privileged communications with the board is recognized by our system of justice in this country since the Constitution, frankly, which perpetuates, the English common law, that those privileges serve justice. They serve the search for the truth. They promote the compliance with the law. They are not an attempt to hide anything. They serve justice and promote truth, and that does include the Board of Trustees.
Let me ask this, if I may, sir. 47 states have figured out a way to put their universities under right to know. Only 3 don't. Delaware, Pennsylvania, I forgot what the third one is. How come 47 states, and all these education systems vary. I mean, they're not all direct that this is how you're structured in 47 states, and Pennsylvania, for some reason, is not structured the same way. They've all figured out how to handle the research, which I think was Senator Smith's question to you. Why do you find it so troublesome and so difficult?
Of course, Penn State is different from every other public university in other institutions because its status is much more autonomous, much more private, much more separate in its historical history. So I would submit to you that the issue of the legal differentness, and this is what I tried to say at the outset, Penn State, and I think it's the great wisdom of the Commonwealth. I think we should be celebrating it, not worrying about it. We should be celebrating the uniqueness, the strength. I believe this legislature and your predecessors have shown great wisdom and inspiration in creating a system in which the state-related institutions, including Penn State, are somewhat separate, do have private attributes, and do therefore come under different kinds of right-to-know open records laws than public research universities in other states, which are frankly different. They just are different. My history with the University of Minnesota, that tells me that. I've done work for Michigan State. I've done work for the University of Iowa. I've done work for the University of California. I've done work for California State University. They're all different. And to try to put a cookie-cutter approach to them, I'm not suggesting, Senator, that's what you're suggesting, but I am suggesting that just looking at how others do it doesn't answer the question of what's best for Pennsylvania, what's best for the Commonwealth, and what's best for our great state-related institutions, including Penn State.
The problem, sir, with your comment is that if we celebrate the wisdom of the past, then we also have to celebrate what happened at Penn State in terms of the Sandusky case. And, sir, that's why we're here today talking about right to know. We don't celebrate what happened in the Sandusky case. In fact, the wisdom of the past in terms of right to know is exactly why we're here today, because many of us feel the university failed. And one reason it failed was because there was no adequate right to know provisions. So while you might celebrate the wisdom of the past, we are challenging that wisdom in terms of a very specific case that has greatly disturbed almost all of our constituents. So, I mean, that's why we're looking at this issue. That's why we're studying this issue.